Good afternoon, ladies and gentlemen. Thank you very much for spending your lunch hour with us. We are pleased to be presenting the latest in the insurance law group at Kelly Santini's webinar series, Ensuring a Cost-Effective Insurance Defense. We are coming to you, the three of us. I'm Keith Gallup, and I'll be moderating the session today, and joined by Sean and Lisa. We are coming to you from boardroom number 3 at Kelly Santini's office in downtown Ottawa. A couple of things just before I turn it over to Sean and Lisa for the content of today's topic. First off, should you miss anything, please, or would like a copy of the slides, please feel free to email Sean or Lisa after the presentation, along with any additional questions you might have. They'd be more than happy to send you some copies of the slides. This and all our previous webinars are also available online. This one will be up in a day or two on the Kelly Santini YouTube channel. So there's it can always be accessed on there. As we proceed through the today's presentation, please feel free to use the dialog box you should see on your screen to send in any questions. We'll save some time at the end of the 45 minutes to address any questions you might have. We'll also have a couple of poll questions which will come up where we're keen to get your input on a couple of questions, and those are multiple choice questions you can just answer using your computer. And finally, at the end of the webinar, there'll be an opportunity just to give your feedback on today's presentation, as well as suggestions for future topics in just a couple of very short, quick questions. So moving on, let me just quickly introduce our two presenters today, Lisa and Sean. Lisa is a partner in the insurance group, the 11-strong member insurance group at Kelly Santini, focusing on bodily injury, property damage, as well as prosecuting subrogated claims. She's appeared on behalf of clients before the Superior Court of Justice, the Ontario Divisional Court, the Ontario Court of Appeals, and various administrative tribunals. Lisa is also fluently bilingual and works frequently with clients throughout Eastern Ontario as well as Northern Ontario, where the bilingual certainly becomes a helpful asset. Sean Van Helden is an associate with the insurance group, focusing on product liability, property damage, motor vehicle liability, accident benefits, including prior loss and transfer disputes, professional negligence, and I think I've just about covered it all off. Sean and Lisa, have I missed anything?
No, I think you're covered it all up.
Good enough introduction. All right, let me turn it over to them.
All right, good afternoon, everyone. So today we're here to see if we can help you try and cut down on your defense costs in the litigation process. I guess the easiest way to do that is not to send it to defense counsel. As Sean and I joke, we love to get new files, but we're here to try and help you try and save on some costs. We're going to talk today about procedures and steps in the lawsuit, civil actions, small claims court actions, and managing costs, as well as preparing a file to send to your counsel, dealing with defense files, as well as subrogation.
I mentioned we would be taking a couple of surveys during the course of today's presentation. So here's the first question, and as well as moderating, I will do my best to launch the question. So up on your screen now, you should see the first survey question pop up. If everybody could just take a moment or two to complete that question as we're watching the answers come in.
So survey number 1, once a statement of claim is issued, what percentage of cases do you settle before sending a file to counsel?
And we'll just give everyone another 10 seconds or so to submit their answers on that. Okay, the votes are coming in very quickly now. Thank you very much, everyone, for participating. They're still creeping up and the votes coming in. Okay, we'll close that, and popping up on screen now, you'll see the results.
So it looks like 43% of you try and settle a case, and then
43% 0 to 10% at the time.
36% 11 to 25% of the time, and 21% 26 to 50% of the time. So Sean and I sort of chatted about this briefly a couple days ago, and it's kind of an important aspect, I think, and it really depends on the corporate policy of the insurance company you work for. Because once a claim is issued, it doesn't necessarily have to be sent to counsel. If you speak to plaintiff counsel right away on the other side, have a chat with them and see if you can have some, discussions, if that's the route you want to take. Get copies of the medical information and see if you can try and settle the case. It really also depends on your rapport with plaintiff counsel. If you trust them, if you had other files with them, chat around the office, see what this person's reputation is like. Because oftentimes the plaintiff counsel may want to get rid of a file relatively quickly. If it's simply just a damage issue and liability isn't a concern, it's something I think the insurers really need to talk about before shipping the file over to counsel right away. Sometimes the concern is, oh my gosh, you've just been served with a claim, we need to get it over to counsel. And yes, that's true, you want to ensure that, the insured isn't noted in default, but if you take those steps yourself, you send a letter to plaintiff counsel advising them of that situation, that you'd want to ensure they're not going to be noted in default. They're not going to do that without advising you first. So I think that's definitely, an inexpensive way to try and deal with the case from the onset. But again, that sort of depends on the corporate policy of the different insurers that you may work for. You also may want to consider just contacting defense counsel and saying, just put a notice of intent in for me right now, just to protect ourselves that way, and I'm going to continue to try and negotiate with plaintiff counsel. If you're not really sure where what the number is on damages, or if there's some liability issues, contact your defense counsel you deal with or that you're comfortable with and say, hey, can you just prepare me a short report, give me your idea on quantum and what your assessment is on liability, and then use that report, that brief assessment from the lawyer to go back to plaintiff counsel and say, okay, here's what I think, and see if that helps. That's kind of been my experience, and I tend to try and recommend that to clients if possible.
And in general, too, if we looked into the 43% that are unable to settle them early on before sending it to counsel, I bet what we'd probably find is it's generally due to a lack of information. And sometimes plaintiff's counsel just doesn't have all of the requisite information at that time, even if it's been almost 2 years since the time of the accident. They're bringing the claim on the cusp of the limitations period expiring. They might not actually have the requisite medicals that you're going to require to properly assess the claim and be able to provide an accurate figure on damages. And we recognize that that's a reality as well. That's one of the things that we face early on as well. However, if there is organized plaintiff's counsel on the other side, sometimes just asking the question and indicating a willingness to resolve it on a reasonable basis can be enough for them to trigger the avalanche of productions that might allow you to do that sort of resolution.
All right, that's very true. Okay, next point, we're going to deal with the procedures and steps in a lawsuit. So first, dealing with civil action. So we're talking about gathering information, the pleadings, affidavit documents, examinations for discovery, pretrial conference, and trial. And then on the small claims court action side of things.
The steps are very similar. Gathering information, pleadings, and documentation with similar timelines, 20 days to file after the claim is processed. And there's a new step after the settlement conference here in Ottawa. As far as we know, Ottawa is the only region that's doing this right now, but it could be expanded depending on how it works out. They've introduced a new step which is called a pretrial conference. And the chief administrator at the deputy court, he's also a deputy judge, has instituted this. This is a last-ditch effort to try and achieve settlement in a small claims matter if it is scheduled for more than 1 day of trial. So it is a thinly veiled effort to clear the docket, and I've had the opportunity to participate in a couple of them, as well as some of the other junior counsel here at Kelly Santini, and our experience has been essentially the same in that there's a couple of minutes of an examination of the evidence, and then the bat comes out, and it's essentially an effort to try and browbeat both sides into a settlement without going to trial. So other than that, I think it's very much like a regular pretrial, and that's something that we can expect going forward here in Ottawa, and that is due largely in part to the proliferation of cases that we've seen since the jurisdictional limit went up to $25,000. We are seeing a lot of claims. In the early days, it was people being willing to shave $5,000 to $10,000 off a subrogated claim or off of a claim and bring it into small claims court. Now we're seeing people being willing to shave $10,000, $15,000, $20,000 off of what they perceive their damages to be and pursuing an action in the small claims court because of the relative speed and efficiency in the resolution.
Just a couple points on the civil action stream of things. In terms of gathering information, I think it's really important, especially once you're given notice of a claim, in terms of the investigation portion of it, to send out, an independent adjuster or whoever it is in your office that does it and get an insured statement right away. It's always, it's always easier for the insurer to give, their hands-on information right at the onset of the notice of the claim as opposed to waiting down the road. So I would highly recommend if you can do that, please get that done because it makes our life easier once we get the file and we actually have an insured statement. We're going to talk about it later on in terms of subrogation, but always thinking, if subrogation is going to be a possibility, get that expert in there and get the expert opinion right off the bat, because down the road again, if you want to try and pursue the subrogation avenue, if you don't have that expert report, it's going to cause some serious problems. Another just a quick highlight in terms of the insured and the subrogation process, just ensuring that the insured knows that that's a possibility, and then if we do go down that road, that the action is going to be commenced in their name. And a lot of times they don't realize that, and so all of a sudden we're calling them for the first time saying, hey, can you attend examinations for discovery? And they haven't really been advised that in fact an action has been commenced. So just pick up the phone, give them a quick call and say, hey, this is the avenue we're going to be taking, and you may have to participate in the litigation process, just so they have a heads up. Makes it easier from our end in terms of dealing with them.
And in addition to that is, with respect to the preservation of documents, sometimes the insurers might not realize that there are some pieces of information that are vital or that could be important. And is often the experience, things that nobody might think is important but can turn out to be. If they're aware that there could be a subrogated claim down the road, our experience is that they are far more likely to preserve things. It's not uncommon for people to put them in a box and store it and wait for that phone call to come.
Especially with emails and electronic devices these days, the amount of email train is crazy, and just trying to keep track of it all. So making sure you're telling your insured to look at that documentation if they have it, and get copies to you so that you can have a look at it and ship it off to counsel when need be. Also, your computer notes, those are a huge tool that lawyers love. I particularly love getting the adjuster's notes because it really gives me a sense of flavor from the case from the onset, from when you're first getting the call, and it really kind of helps give a good history of the file. So please, send those along with the rest of your file. It's quite helpful. On examinations for discovery, just quickly, just so you know, the trend nowadays in terms of the subrogation, we'll get into it a little bit further, is that you may be called as a witness to support the quantum aspect of the claim. It's much easier to get the adjuster who knows the file quite well and to justify why they spent the money they spent on the file than trying to get the insured and deal with it by way of undertaking. So.
Yeah. And of course, in the small claims actions, there is no examinations for discovery, which on the one hand is efficient, but on the other hand can also lead to a lot of problems. It's not uncommon to attend a settlement conference in a matter, and for the first time the parties actually have an opportunity to have a conversation with the other side and find out all sorts of new information. This is, I think, part and parcel of why the new pretrial conferences are being scheduled, is because of these longer, more complex actions that are requiring more time and investigation. There's a lot of production typically between the settlement conference and the trial, and if given that one more opportunity to try and resolve the matter, it's usually quite successful. So that is something that we try to keep in mind, is there are limits to how much information we can get before the settlement conference, but at the same time there are limits to what we are required to disclose as well. So it's one trend that we see is as you see more and more experienced counsel involved in the small claims court actions, we're seeing greater productions earlier on, and that just helps everybody.
Yeah, that's a good point. And just a little tidbit, a little fact for you. On the civil action side of things, so Superior Court, only about 5%, even sometimes less, maybe between 4 and 5% of cases in auto are actually going to trial. So only a small percentage. Sean, do you have any idea in terms of the trial in small claims court, what that percentage is?
It's definitely a lot less. One of the more troubling trends that I've seen is particularly in the small claims court is a lot of self-represented litigants that take unreasonable positions and cannot be persuaded by judges who have the power to dismiss an action but won't do it because they don't want to be perceived as an impediment to the administration of justice. And the result of that is there have been quite a number of trials that will go to trial that quite frankly shouldn't, because there aren't legal issues to be resolved. They are really factual issues that tend to get resolved very quickly early on in the trial. That said, again, the settlement conference method is largely successful, and we also have seen here in Ottawa and in some of the surrounding regions a greater emphasis on resolution at the settlement conference versus what we used to see, which was some conferences lasting 30 seconds to a minute, exchanging lists of witnesses and setting it down for trial.
Yeah, that's interesting. It seems to be a real trend these days, and I'm sure all the adjusters have dealt with it a lot, dealing with the self-reps, and that's always the self-rep factor, as I call it. So you got to tag on a percentage of increased legal fees when you're dealing with these kinds of situations in self-rep. So unfortunately, as soon as you have a self-rep on a file, that's it's not going to be a cheap file, usually, from my experience. All right, so next slide. Dealing with simplified procedure, just in terms of a quick summary, what the differences are between simplified procedure and regular rules. You're dealing with a $100,000 limit on simplified, 2-hour discovery, which is nice because it sometimes can get you in, get the information you need, and you don't have to spend a ton of time on it. And then a summary trial is available.
And one of the more positive trends is with increased familiarity and use of the simplified procedure rules is a lot of the bodily injury claims that are clearly under $100,000 in recoverable damages. We're seeing claims brought within these rules. Counsel on the other side is obviously aware of the fact that these claims are likely to proceed faster, which means an earlier resolution and at a lower cost. You mentioned the self-reps a moment ago, and that's one of the other advantages in the simplified procedure is with respect to motions that are brought in the simplified rules. We recently had an experience where a self-rep plaintiff did not file any responding materials to our motion to have the case dismissed. And of course, this raised the specter of potentially having to persuade a judge to proceed essentially ex parte against a self-represented party. However, there is a provision in Rule 7605 which governs simplified procedure rules, and I'm not sure if the intent of the legislation was to contemplate a situation like this, but it tends to be invoked in this type of a situation. Essentially what the rule provides for is if a responding party doesn't file materials, the moving party can simply take the order to the registrar and have it enforced. And we found out on the day of our motion that there's actually not even a need to wait till the day of the motion if they missed a deadline for filing responding materials. However, I would advise if you choose to avail yourself of this opportunity with a self-represented or even just a lack of diligence on another side, it's best to wait until the day of just to ensure that they don't try to avail themselves of any last-minute delays or impediments to their being able to file on time. If they appear, that's clearly a different story. But that has turned out to be a very efficient mechanism of resolving motions, particularly where, in our case, as it was a motion to dismiss the claim.
Okay. On the regular rules side of things, there's no monetary limit, and as you know, I don't think anyone hates it more than I when we get a statement of claim and it's for this multi amount of money, and basically there's threshold issues and contrib issues, and it's a disservice to everyone when those kinds of claims are issued, but they are, so we're stuck with that. So there's no monetary limit, obviously. You're dealing with a 7-hour discovery limit normally, but on consent or leave you can get more time to actually do the discoveries. And as you'll see from a lot of you obviously have dealt with defense counsel enough in litigation as a whole. The expensive part of litigation oftentimes is a discovery process because of the cost of meeting with the insureds, preparing with them, reviewing all the medical documentation, attending the examination, and preparing the report. So that's always an expensive measure. So if you're in a situation where you can go to mediation, not necessarily go to discoveries, that can also always be a cost-saving measure. So something to consider when you're having discussions with your counsel from the onset. Case management is a really good tool and can always be a cost-saving measure because it helps move the litigation forward. If for whatever reason with your counsel things aren't moving along, or the lawyers tend to be dragging their heels and trying to get scheduling and that done, just ask your lawyer, well, what about a case conference? Let's try and do that. And that's obviously allowable in Ottawa. It's not the same for all the jurisdictions, but at least the date gets scheduled at the court. All the parties have to show up. You go before a master, and then a timetable is set. If the counsel can't seem to figure it out themselves, which often tends to be the problem because of scheduling issues. So at least if you get a case conference, you can get the dates, get mediation examinations, whatever it is you're doing first, and get the file moving forward, which I know all the adjusters like to see. The last thing you want is a file sort of sitting around and not moving in the right direction.
And on that point, Lisa, I've been doing this for about 4 years now. I wonder what your experience has been. Mine has been that the longer these files tend to go on, regardless of the amount of damages claimed, the costs just seem to increase. And for that reason, it seems desirable in just about any situation to try to push for a fast resolution. And the management tool is a very useful one for plaintiff's counsel that might just be unresponsive with no reason given.
No, it really is. And the idea is you have to move the files forward and keep things scheduled and keep things moving, because if not, you're right, some plaintiff counsel will just sit on it, and it just takes forever to get the thing moving. So definitely a good point. All right, next, survey number 2. Sean, what is this question here?
What steps do you currently take to reduce costs? These are steps that we know that some adjusters take, and we just like to understand from your perspective.
The poll is now up on your screen, and you can please tick all that apply.
So in terms of the steps, attending examinations, requesting summary reports only, negotiating reduced fees with third-party providers such as investigators or health professionals, paperless communications, and effective use of Rule 49 offers, and any other tools you may use. And one of the big ones Sean and I had an interesting discussion about is dealing with reporting to insurers, and what the preference is and different corporate policies. So, it's really important when you first get, defense counsel assigned, let them know what you like. Do you like a fairly detailed initial report and discovery report that's very lengthy, that's very long, or are you looking for something more, shorter, succinct, which obviously is going to probably be less expensive, or do you want really a summary of the evidence? So I think it's important that, you look at that and have those discussions with your counsel and let them know what your preference is, because we're here to service you and give you what it is you're looking for. So it's important that that you consider that and have the open discussion with your lawyer and tell them what you want.
Exactly, and especially depending on the length of the examination, if it's a relatively brief one, which I would characterize as anything under a day, in some cases, if there's a familiarity with the file, a summary of the transcript, or actually providing the transcript itself along with a brief summary of the evidence and key recommendations, might be sufficient for the file. I know, quite frankly, here internally, a lot of the times the summary of the examinations for discovery is useful for both sides, because there are so many cases that a lot of times down the road it's a very easy tool to use to refresh the memory rather than having to dive through the file again and to go through that examination summary.
Okay. Most people have had a chance to submit their answers now, so I will close the poll and share that with everyone. So now you can just see what everyone is.
So in terms of reducing costs, 53% attend examinations, and that's a good tool because you really get a flavor for the file and really get to see the parties and be able to assess their credibility as well. And that you take your own notes, so you don't necessarily need to get a summary from the lawyer, and just get a simple assessment from them. So that can be a way of definitely reducing the cost. Requesting summary reports only, 73% of most of the adjusters do that, and that seems to be the major trend, because not everyone has time obviously to go to the examinations, and getting a summary is a really useful tool and helps you assess your case and set your reserve. So that tends to be the trend. Negotiating rates, that's also quite, that seems to be 37%. That actually surprises me, so that's actually quite positive. Paperless communications. Paper is going to kill us, especially with the emails out there. I think it's much simpler to try and deal with it that way than have.
Yeah, especially with the productions being available. I know we make prolific use of our scanner here. I was on examinations for discovery recently in Sudbury, Ontario, and it was interesting that myself and co-defendants counsel got off the plane with no more than our iPads. And each of them had hundreds and hundreds of pages of documents that have been collated, organized, highlighted, and stored and easily accessed. And, of course, our notes were all taken as well with that. The sort of technology that we have available right now is just light years ahead of what was available 5 years ago, and the availability to go paperless is great. So the extent that we can integrate that with our clients and even with the insured, it just makes communication much faster, and it also cuts down the costs a lot.
Yeah, I'm not sure if you're seeing a lot with the adjusters you're dealing with, but a lot of the files I'm getting is just CDs with the scanned documents, or just an email with all the documentation, which is super helpful. And that way it's preserved on our system, and it makes it simple, especially with your traveling to do examinations and for mediations or whatever. So for those of you that are doing that, I think it's a really positive. If you're sending paper, that's fine too, whatever works. I personally love paper, but I think someone younger like Sean, is he much younger? I don't know how much younger Sean is, but it really depends on what the adjuster prefers to do. So.
And with the 53% that are attending, or 57, sorry, attending examinations, that is fantastic. I'm reminded of my previous career was in marketing and brand management, and we worked with a lot of consumer research. One of the researchers, only once in 8 years of doing that, did he actually put us in the room with the consumers. And he told us the reason he did it afterwards is there's a difference between reading something on paper and knowing it in your gut. And especially in examinations on some cases where the credibility of a particular witness or of a party is going to be at issue, and also just the memory of the key elements of it. When you're in the room and you hear it and you see it, you get a real visceral sense for it that sticks in the memory. And with as many cases as we have on our desks, it really helps with respect to the memory, but also with respect to the judgment down the road that's going to be exercised in evaluating the claim.
No, it's so true. Especially in the credibility, you always have those cases. You try and explain to the adjuster where the plaintiff is explaining their situation, they're too much pain, they have to lie on the floor, and they start yelling into the microphone to try and explain the questions and answer. And trying to explain that to the adjuster is always different than the actual adjuster there, sort of observing it all. So it's pretty interesting. All right, next slide. Effective use of Rule 49 offers, that seems to be 39%. So that's also a very effective tool. Managing costs. Mediation versus discovery. I do a lot of mediations now as a mediator, and so I'm a big proponent of mediation, and I think it's a really great way to try and save on costs, especially if liability isn't necessarily an issue. You're just dealing strictly more with quantum. It's a good way to try and get the case done quickly and move forward. But in that, I think you need to be mindful of the mediation fees, because that's an area where I think you can save on costs. There's a lot of really qualified mediators out there, and there's a huge range of costs as to what they're charging. So I think you need to be mindful of that and do your research when a lawyer is suggesting to you what mediators to use. Have a look and see what kind of money they're charging, because that's easy cost-saving measures. If it's a simple case, use a roster mediator. If there's two parties, it's $600. It's a reasonable amount of money, and if there's not going to be huge issues at stake, it's a cost savings to the insurance company. So really look at that and see that's easy money to save, and do your research and have a look.
On surveillance, the first question is obviously why and when. What use or do we plan to make of the surveillance, and when to get it? Especially dealing in Canada, the when is a big factor in terms of trying to capture somebody doing meaningful activity. Because in the wintertime, depending on what province they're in, but especially in Ontario, there's just not a lot going on, and people that might ordinarily be gardening outside, cutting wood, if they're in rural areas, or even in town running errands, that gets cut back a lot in the weather. And then again, with respect to winter, you never know when you're going to have a day like we have today in Ottawa, where we were expecting 5 centimeters of snow, and it's essentially been snowing nonstop since about 8:30, 9 o'clock this morning.
Good point.
So anybody who had any plans to go outside today has probably curtailed them significantly. With respect to why, again, the use there is, do we want to hang on to something and impeach if there's a great disparity between the plaintiff's position and what we think is a reasonable resolution, or is it going to be surveillance that is going to be used to demonstrate to plaintiff's counsel that their client's case may not be as strong as it is? And that's one of the things we try to keep in mind too, is we often need to give plaintiff's counsel the benefit of the doubt, because they only know the side of the story that they've gotten from their clients, and sometimes they can be just as surprised as we are at some of the content of the surveillance we obtain.
And I find a really fun tool is Google. Google is your friend. So, help out the PI that you're hiring. Do a little Google research. See if you can find anything. Facebook, if you can see to get into their Facebook, and if they don't happen to have any restrictions, have a look and see if there's any helpful hints as to what they do in their spare time or whatnot, and see if you can get them doing something interesting. I had a file where the individual on the face, they just hadn't, I guess, applied the restrictions, and all of a sudden one of the defense counsel sent over this picture of this individual who had very, very serious lower back pain, wasn't able to barely walk, and had difficulty sitting and standing, and this beautiful picture of him skydiving, and then bungee jumping as well. So, it was pretty entertaining to see that it was just simply on their Facebook page. It was simply printed out, and it was at the relevant time period as to when they said they were injured. So, Google, Facebook, all those social networking sites, definitely
YouTube
your friends. Well. YouTube, great. So, have some fun with it, have a look and do your own little investigation and see what you can find out, and that way it can always help the PI out and try and save you some costs there.
And with respect to experts, I'm just going to jump down to the last point there, using the expert creatively. There's a few different ways to do this. One of the ways that we've seen and have been willing and have done it is not getting a written report initially from an expert. Sometimes you just might want the expert to go and take a look and perhaps provide an oral report. And the reason for that is once it's put into writing, we need to disclose the report, whether we use it or not, whether it becomes part of our Schedule B or Schedule A, the other side's going to know about it. And it's pretty clear when an expert report appears on a Schedule B, really the only reason that would happen is that because it's not good for your case, and the other side will see that as well. So if there is nothing in writing, then that can be an advantage as well.
All right, good point. All right, so let's move along to question number 3, survey. When do you retain counsel for subrogation? Immediately or soon after a claim is opened, weeks or months before the prescription period expires, the day the prescription period expires.
The poll is now up on your screen.
While we're waiting for that response, I just wanted to touch on the last point that we had in the last slide, that was offers to settle, time limited versus Rule 49. And time limited is self-explanatory. These are offers that are typically made to try to incite some sort of action versus a Rule 49, which is hopefully something that has been well analyzed, thought out, and is one that you're willing to carry all the way to trial as an offer that you genuinely don't believe they're going to beat. The use of the time limited, of course, is, although we understand that adjusters and companies have certain times of the year where they may be more incented to close a file, the time of the year for plaintiffs is really always, especially when they're looking at having a number in front of them that they could walk away with today versus the uncertainty of how much longer the case is going to take and how many more steps they're going to have to go through and whether or not they may collect as much down the road.
That's a good point.
Okay, thank you very much, everyone, for submitting your answers, which we'll share with everyone now.
All right, looks like 28% immediately or soon after will retain counsel. 67% is weeks or months before the prescription period expires. And I like the honest people in the House, 4% the day the prescription period expires. And it happens. I mean, we all are busy. You're trying to BF your system, and you're trying to get things moving, and you're hoping maybe the case is going to resolve or whatnot. And so, the council does get the file the day of. And, and it happens. We get a notice of action out or kind of scramble something together and we get it done. It always gets done, not to worry. But I like the honesty out there in the crowd, so 4%.
Yeah, and even if at that point in time you might say, the prescription period's tomorrow, but I need another week before it's out. If we want to progress on this, we can get the claim issued and sit on it. It doesn't have to be served right away. So don't be afraid to make that call. We get them a lot. And
we have 6 months to serve. Yeah, we have 6 months to serve the claim without having to bring another motion, which will cost you more money. So 6 months is a good time frame to get the file, to get the case served. So not to worry, we can get the claim issued for you. Preparing a file to send to counsel. This is always a fun one. Defense versus subrogation. So we're going to deal with subrogation first. I do a lot of subrogation, which I really enjoy. It's always fun where you get paid as opposed to paying out. And I know the adjusters I deal with like to get some money too. It's nice to see. It's really important that you think subrogation immediately. So as soon as you're getting the file and you think potentially there could be some parties out there that are going to be ultimately responsible for your payout, put them on notice and let them, give them a heads up so they can conduct their own investigation. And don't be shy, even if maybe you're putting the wrong party on notice. It's not going to be the end of the world because you haven't sued them, obviously. But, don't be shy about that. Obtaining experts report early on, super important, because if you get one later on and they haven't actually had an opportunity to really attend and visually see everything, getting an opinion later on gets a little bit more wonky. So I would highly recommend, if you're thinking subrogation, get an expert opinion immediately.
Another advantage to even putting the wrong party on notice is they will typically respond and tell you who the right party is.
Yeah, that's a good point. That's so true.
And that's a huge advantage, especially when timelines run down to the end, because we can do certain things to amend a claim if the wrong party's been named, but there are other circumstances where if you're out of time, you're out of time and there's no opportunity.
So, yeah, the more the merrier, I guess, is my view on that. So next slide. We sort of covered off of putting people on notice. Obtaining witness statements, we talked about that earlier on, really, really important. And, I know the adjusters are swamped and you've got huge file loads, but if you can send independents out there to get the witness statements, so important on the subrogation files because the information you're getting from the insureds right away is so much more relevant than down the road or at examinations for discovery, preparing them or whatnot. So if you can get the witness statements, spend the time, have someone from your office go in and do that, it really makes our job so much easier.
And if any of you have had the opportunity to attend a trial or even some examinations on occasion, you see lawyers frequently making use of prior statements to catch somebody in an inconsistent statement. And typically it'll go along the lines of, well, was your memory clearer about the event now or then? And no jury report in the world is going to believe that somebody's memory is clearer 5 years after the fact as compared to the statement that they might have given a few days or a week or a couple of months afterwards.
Continuing on with subrogation, determine the quantum, consider betterment. So on the quantum, that's always a challenge. And when you're sitting there paying all the checks and dealing with, let's say, on an oil spill case, which can be massive, and the remediation involved, and things are getting to the hundreds and hundreds of thousands of dollars, which is very common on the oil spill cases these days. Don't be afraid. I mean, obviously it's a corporate decision from your insurer's perspective, but don't be afraid to maybe get a second opinion, because what happens is if this becomes a subrogation file and down the road, you're going to be attacked by the other parties on quantum as to why you paid out, why did you spend so much. They're going to get experts looking at the remediation expertise that you had and why they decided to take certain routes and why they chose to do the remediation in that way. So, you know, if you're thinking subrogation, you're thinking this is going to be a big file, don't be afraid to get a second opinion to make sure that the remediation expertise you're getting is on point and reasonable and that they're not being too excessive in their fees. We all know that sometimes that happens, unfortunately, and it's going to be an issue come quantum when you're getting attacked on at mediation or pretrial or trial, dealing with the amount of the claim and what was decided upon. On that as well, like it becomes important to really prove the damages and what you've spent on the file. So I know it's a pain, but keeping, you know, getting all the checks, and I often have to ask for that from my clients because that's what the other parties want. They really want to justify the exact amount that was paid out on the file and ensure that that's being done. So just supporting that position. You also have to keep in mind that your insured is also entitled to claim for any personal claims that haven't been covered by the insurance policy. So making sure that that question has been asked of the insureds and that, you know, obviously the lawyer has to ensure that as well because when they're issuing the claim, the number has to be reflective of the fact that there's an insurer perspective in terms of what's been paid out as well as a personal interest of the party because sometimes you have to go back and then amend your pleading because the amount has then changed. So just making sure that you're keeping the insured happy, letting them know that they get to piggyback off this as well and move forward that way. Next point, you don't need to wait until you have settled with the insured to subrogate. Really important, you don't have to wait until then to issue the claim. You can issue the claim at any point. The Insurance Act provides provision to allow you to do that. You just have to ensure that at the end of the day that the insured under the Insurance Act gets to get paid out first if there's any kind of settlement. So keeping that in mind when you get to mediation. Sometimes that becomes a bit of a debate between the insured and the insurer as to the amount that should be paid out and percentages and all of that. So the insured technically should be getting paid out first.
So we touched briefly on limitation periods and issuing the claims, and again, issuing the subrogated claim sooner avoids any respective issue that you may encounter with that. The other one is, as we touched on also, is naming the parties. And as we said, misnomer or misdescription of the party is correctable, but what's not correctable is failing to bring the claim against the proper party or bringing a claim for contribution and indemnity against the correct party as well. And unfortunately, there is recent case law on that where somebody tried to correct a failure to bring the proper claim against the correct individual by bringing it as a misnomer misdescription, and the court said, no, this was just a failure to add the right party and you're way out of time to do so now. So it's really important to do that. And then the last point is, again, we've already touched on it, tell the insured the action will be subrogated. In addition to all the other reasons that we've added right now is sometimes the insureds need a gentle reminder that they do have a duty to cooperate.
Good point. Friendly reminder. Last point on subrogation, send everything to your lawyer. I know it's a time-consuming process going through all your documentation, your emails, all your adjuster notes, all of that, but we love paper or scanned versions or whatever it is, but any documentation you can provide to us is going to be of assistance, and whatever, you may not think it's going to be helpful, but at the end of the day, some things turn out to be very helpful and you may not have thought so. So don't be shy, look through your files and try and send us whatever you possibly can.
With respect to defense file, obviously the first question might be, do you need a coverage opinion? And that is often the case. Quite frankly, the way the law is changing these days, sometimes you might not think you need a coverage opinion. It might be clear, and you do. And specifically, I'm thinking of two recent cases. One was a decision of the Court of Appeal, came out last September. The citation, if you're interested, is on Canley. It's 2012 ONCA 641, and that's Aitken v. Unifund. And what happened in this case is a home purchaser brought a lawsuit against the individuals they bought the house from, and they alleged that there was a leaky roof that had been deliberately concealed. The importance of the fact that it was deliberately concealed is that they only pled intentional torts as against the defendants, and for that reason the home insurer understandably denied coverage. What was interesting about this case is after examinations, the plaintiffs apparently were asked to add unintentional torts to the claim. They did so. And on motion, the insurer was ordered by the court to assume the defense of its insured because of the unintentional torts that were pled in the claim. And in this case, what was interesting about that, again, was that the unintentional torts weren't even added until after the motion had been brought. And so in the situation where you've got potentially a clear-cut issue of coverage or denial of coverage, it might not be so clear-cut. And on the motor vehicle side, I'd also point out the case of Tutt versus RBC. That's a year old now, 2011 ONCA 644. If anyone's interested, you can send me a note afterwards as well. Again, this is one that is difficult to reconcile with the wording of the legislation, the state of the law, but it's essentially it's a situation where a young man who had a G2 license and was not allowed to have any alcohol in his blood while he was driving was drinking on the night of his 20th birthday. The next morning, drove some of his friends home in his mother's car, had an accident, and 2 hours after the accident tested at 1.5 times the legal limit. Coverage was understandably denied again in that case. However, the court said he had a reasonable belief that his alcohol level was 0. And because they found the offense to be one of strict liability, that is the offense of driving with alcohol in his blood, strict liability versus absolute being that the defense of due diligence is a defense to that. And the court's wording on that was they're trying to balance the high standards of protecting the public safety versus what is perceived as the public's revulsion against punishing the morally innocent. Again, difficult to reconcile this case. There's a slightly older decision, almost the same facts, where a young lady drove her car with a G2 license on a highway when she wasn't allowed to drive on a 400 series highway, and her defense was she just didn't know that it was a 400 series highway, and of course the court said it doesn't matter. That's the term of your license. So coverage was denied. In this case, they would have thought they saw the same outcome, but it didn't. So all of that to say, coverage is an ever-changing beast, and obtaining an up-to-date coverage opinion, or sorry, a coverage opinion on the up-to-date case law can be important depending on the reason that you're denying coverage.
Okay, very helpful. Moving forward, if you think a party is responsible, put them on notice. Sean and I have chatted enough about that. We won't harass you to death about it, but put them on notice. No problem. We like that. Next one, don't forget to tell the insured that they have a lawyer. Yeah, we've talked about that. We won't hammer that one home. So please ensure that they know that we are there for them, and hopefully they won't be annoyed when we call them. Send everything to your lawyer and send it fast. Paper, scan it, whatever way you want, whatever method you like, just send it all to your lawyer and we'll deal with it. So I think that sums up our little presentation here. So thanks everyone for listening. It's been very entertaining from my end. I've been trying to contain my bronchitis and not cough.
Thank you very much to Lisa and Sean for taking us through that. Anyone who would like to send in a question for Sean or Lisa, please feel free to make use of the question dialog box, and we have a few questions that have come in, and we'll just give everybody a chance to send those questions in, and in the meantime we'll give our plug to Buckleys, who have very graciously helped Lisa get through her bronchitis over the last hour. She took some just before starting, and it seemed to have worked apart from one bout which she was able to step out of. So we do have one question that's come in. Do we need to assign separate counsel to add ourselves as a statutory third party?
No, you don't. You don't need to do that. It would be the same counsel that you're retaining, so you don't have to do that. That's an easy one. Okay.
Okay. We are. It's just creeping up on 1 o'clock, and I know if anybody has any questions that they'd like to email to Sean or Lisa, please, they'd be more than happy to hear from you, or if you'd like to receive a copy of those slides, please just feel free to get in touch with them, and we will be happy to send those off to you. It's now 12:59 on our computer, and we're wrapping up at 1 o'clock, so we will just take this opportunity to say thank you very much for participating. Thank you for spending your lunch hour with us, and we look forward to presenting our next webinar in a few weeks' time. Thank you. Have a great day.
Thanks very much.